I, Raghav Mudgal, welcome you all to the final leg of this 3 day Society of Construction Law India International Virtual Conference on Construction Law and Arbitration. Before we move ahead, we would like to declare the winners of the Construction Law Trivia organized by Atkin Chambers, London. Our second runners up for the quiz is a team from ICOM Private Limited, comprising of Mr. Pranshu Agarwal and Mr. Febin Anthony. Our runner-up for the quiz is a team from Indus Law Firm comprising of Ms. Prerna and Ms. Aishwarya. And finally, our winners are, cue drum rolls, a team by the name of Dreamers. We congratulate Mr. Raghubir and Ms. Anika for winning the Construction Law Trivia. As we enter the last leg of our international virtual conference, I'm personally thrilled to introduce to you our chief guest for the closing ceremony, Mr. Gary B. Bond. Undoubtedly, he's a preeminent authority and publicist on international commercial arbitration, whose treatise on arbitration is perhaps the most cited or referred worldwide. I know I have, especially in my moot court competitions, relied on him and always find myself going back to his books every time I want clarity on the subject. It is great to see him here today. Mr. Bourne is the chair of the International Arbitration Practice at Wilmer, Cutler, Pickering, Hale, and Dorr. Mr. Bourne has participated in about 700 international arbitrations, which include some of the largest and most significant arbitrations in recent history. I welcome Mr. Bourne wholeheartedly and request him to kindly address the delegates.
Thank you so much for that very gracious and flattering introduction. And thank you also. Thank you to the Society for Construction Law of India, and most importantly to all of you who today are taking your time out of a busy weekend, a happy weekend, I hope, to listen to my brief remarks. It's an honor, it's a privilege to be able to address you all today, if only virtually. I hope at some point we'll be able to do this again in person, but for the moment, I think virtual or remote is going to have to do. I know that these are closing remarks, so I'll make sure that they're brief remarks. I know that you're all eager to get home. And I tried to think what sort of message, what sort of brief summation of what has happened over the last 3 days could I leave you with so that you could take something away about arbitration, about dispute resolution with you for the future. And so what I thought I'd do would be to talk just briefly about why it is that we have arbitration, especially why we have international arbitration. And in the interest of trying to make this memorable, I'm sure that I personally won't be memorable, but perhaps the message can be memorable, something you can take away with you. I decided to title this the 6 E's, or perhaps the 5.5 E's of international arbitration, that explain why it is that businesses, why it is that their advisors prefer international arbitration to other means of resolving their cross-border disputes. What are these 5.5 or 6 E's? They're the advantages that international arbitration has compared to the competition, compared to alternatives like national court proceedings. In summary, and I'll then say a few words about each one of the E's, the 5.5 or 6 E's are: international arbitration is more expeditious and also more efficient. International arbitration is more expert and even-handed, and in the scheme of things, more enforceable than the alternatives. And then the half or the 6th E is international arbitration, at least these days, and perhaps also I think in the future, international arbitration is more electronic than the alternatives. And for each one of these reasons, but in particular, when you look at them cumulatively, when you put them all together, international arbitration provides a better, a superior means of dispute resolution as compared to national court proceedings. And that includes the so-called international courts that have been founded in some jurisdictions, whether Qatar, Singapore, or China. Let's begin, though, with why international arbitration is properly used more expeditious than the alternatives. Part of the reason is because in many national court systems, I won't speak about any particular jurisdiction, but I'm sure that some of you can imagine which ones I have in mind. Proceedings take an intolerably long period of time, even just in the first instance or trial court, but certainly when one looks to appellate proceedings, national court proceedings. There are a number of member states in the EU where this is in particular correct. Can take many years. I recall once asking what the date for an appellate hearing was, and I was told quite literally a decade hence. International arbitration, in contrast, has procedures that are designed by the parties or by an arbitral tribunal whose mandate is to conduct the proceedings efficiently. In many recent innovations to institutional rules, fast-track proceedings for smaller value cases have been adopted under the ICC and the SIAC institutional arbitration rules. Smaller value cases, somewhere between $2 and $5 million US, are heard on a fast-track procedure, with an award coming no later than 6 months after the tribunal has been constituted, with the proceedings being conducted by a sole arbitrator. Similarly, procedures for early dismissal, emergency arbitrator, and the like have adopted innovations to the arbitral procedure that allow it to be conducted much more efficiently than alternative dispute resolution mechanisms. And of course, as we all know, arbitral awards are not subject to appeal. At most, there's a possibility of annulment, which is on very narrow grounds and which in many judicial systems is one-stop shopping in the sense that you go to a specialized court. And for all those reasons, therefore, international arbitration can be conducted more expeditiously, more quickly, which is, after all, what many businesses desire. The second E, and quite closely related, is international arbitration can be more efficient. And that follows from its expedition because, as we all know, time is money, and the more quickly you can resolve a dispute, the more quickly you can stop paying your lawyers, and more quickly you can stop being distracted from your business. In addition, arbitral institutions have developed keen and sharp pencils to scrutinize arbitrators' fees and have tried to ensure that the arbitral process meets its aspirational goal of being more efficient than the alternatives. Again, as well, the parties' mutual desire to save money, together with their shared procedural autonomy to control the arbitral procedures, helps ensure, in most cases, not all, there are examples of arbitrations going awry, but in most cases that the arbitral procedure is more efficient, saves time and money better than the alternatives done. For some of the same reasons, the third E, international arbitration, is more expert, is also a superior feature as compared to national court proceedings, where in virtually all instances, the judge is a judge of general jurisdiction, a judge who must decide tax cases, criminal law cases, administrative law cases, environmental law cases, constitutional law cases, an entire gamut of different types of civil and criminal, as well as administrative disputes. International arbitration, domestic arbitration as well, is fundamentally different. In international arbitration, the parties select the arbitrator after the dispute has arisen. They're entitled each to select one co-arbitrator without a veto from the other party, and together the two co-arbitrators select the presiding arbitrator, or alternatively, a specialized neutral arbitral institution selects the presiding arbitrator. In all those cases, the parties have an incentive to choose arbitrators who are expert in the type of dispute that has arisen. If it's a telecommunications dispute in the Middle East, they choose arbitrators who have experience in that type of dispute. If it's a construction dispute, they choose construction experts instead of, for example, choosing me. If it's an insurance dispute, they select experts in insurance law. And for those reasons, one almost is guaranteed a tribunal with vastly greater personal expertise and experience, which in turn enhances the accuracy of the dispute resolution process. The parties know better than anyone else in the world, and they have the most incentive of anyone in the world to choose a tribunal that is perfectly suited to resolution of their dispute, rather than taking a one-size-fits-all national court judge off the shelf and expecting him or her to learn a complex new subject overnight. The fourth E, even-handedness, is particularly important in international matters. Rather than litigating in the home courts of one party or the other party, a U.S. party litigating in Chinese courts, or a German party litigating in Indonesian courts against a counterparty from that jurisdiction, parties arbitrate in a neutral, even-handed international forum, an arbitral institution whose obligation it is to be independent and impartial, appointing a tribunal subject to those same obligations, almost always in a third country. The aim being in international disputes to be as even-handed, to be as neutral, to lack the difficulties that arise from national bias to the greatest extent possible. And arbitrators themselves are subject to potential challenges, subject to stringent obligations of independence and impartiality, all of which enable the arbitral process to produce, especially in international matters, a decision that is more even-handed, more neutral, more objective than the alternatives offer. Finally, as we all know, international arbitration is also vastly more enforceable than the alternatives. The New York Convention, with nearly 170 contracting parties, obligates states all around the world, and states which for the most part have faithfully honored these obligations, to both recognize and enforce international arbitration agreements and arbitral awards, subject to only very limited exceptions. There's been an impressive track record over the last 50 years of national courts actually fulfilling these promises. And in comparison, there is no competing convention to the New York Convention with respect to either choice of court agreements nor national court judgments. You may have heard passing references to the Hale Choice of Court Agreements Convention. That is poison. One should not adopt that convention. It's made very serious errors in trying to adapt a mechanism suited for international arbitration to the process of choice of court agreements and national court judgments. Most countries have wisely declined to ratify that convention, and I would certainly hope that that would continue to be the case in the future. Finally, I promised you not just 5 E's, but 5.5 or 6 E's. Since the pandemic, since the lockdowns and travel restrictions that we've seen over the past 2 years or so, international arbitration has, with extraordinary nimbleness, managed to move online just as this conference has. One might have thought that caseloads at leading institutions would go down, or at least that the number of hearings would decrease. In fact, the opposite has happened. There have been more filings at leading arbitral institutions. There have been more arbitral hearings at institutions and also in ad hoc arbitration than there were prior to the pandemic. In contrast, many national courts, although they've attempted to go online, have done so with mixed success. Alternatively, in some countries, remote hearings have been permitted only with the consent of both parties, and finding a respondent who consents to having a hearing go forward is a difficult task indeed. And thus, international arbitration has, using the technology of the day, managed to adapt itself to a new environment, whereas in the past, by definition, international arbitration required people crossing borders to different jurisdictions. Today, we simply use Zoom or Teams or some other mechanism to continue with our hearings with, at least in my experience, admirable success. And so it's for those reasons, the 5.5 or 6 E's, that international arbitration has been the natural choice for resolving international cross-border disputes. I expect it to continue to do so with your help in the future. Thank you all very much. It's been a great honor and privilege again to be able to address you today.